The Administration of Criminal Justice Act, which placed a premium on sentencing offenders without having to go to prison in what's called non-custodial sentencing, has been on since the law came into effect in May 2015, but the provisions have hardly been fully implemented. The new measures, which include fines, community service, probation, a combination of probation and community service, and conditional or absolute discharge, have been hailed as being novel in the approach to decongesting prisons. But in reality, non-custodial sentencing doesn't seem fashionable among Nigerians, even as correctional centers or prisons remain overstretched, housing mainly awaiting trial inmates living in very poor conditions amidst the rising cost of feeding them. At this two-day workshop, the Attorney General says the federal government has set out guidelines to stipulate the requirements and procedure for imposing non-custodial sentencing for the purpose of preventing abuse. Fagbemi, who was represented at the event by a Justice Ministry official, says even though these are early days, there are already some positive developments since Nigeria embraced the new measure.
Today, we have seen countless cases where defendants are arrested for minor offenses and locked up in prisons, adding to the population of awaiting trial inmates. These offenders, remanded with hardened criminals, end up being initiated into a life of crime instead of being reformed. The use of non-custodial measure has facilitated reduction in our correctional facilities. It is our hope that the non-custodial measures and sentencing guidelines will be more operational and effectively implemented.
Among those present at the workshop are magistrates, judges, and staff of the Nigerian Correctional Services. A number of issues, including sentencing minors to adult prisons, up for discussion.
Instead of serving the sentence in the prison yard, you now tell someone to sweep the court premises, or you go to the market square, sweep the market, so that it will not sound as a deterrent to others.
We have been given the power to reject underage inmates. So when such inmates are brought and we confirm that they are really below the age, we reject them, irrespective of what is written on the warrant. Because what they usually do is to put 19, 20, 22 years. But when you look at the offender, the accused, you find out that that age does not correlate.
Key among topics that we highlight the two-day workshop include that on strategies for implementing the FCT High Court custodial and non-custodial sentencing guidelines. Godfrey Eshamoge, Arise News.